Hello everyone. My name is Farid Nasution, partner in the competition practice group at Asgaf Hamzah and Partners, part of Raja Intan Asia Network. I welcome you to the first episode of AHP vlog and podcast series. In this first episode, we will recap the major developments in the enforcement of competition law in Indonesia in 2018. We will also give you a general outlook on expected developments for 2019. The first thing that we will be covering is the appointment of new commissioners of the Indonesian Competition Commission, or also known as Komisi Pengawas Persaingan Usaha or KPPU in Indonesia. After a lengthy and dramatic setback, in April 2018, the House of Representatives concluded the selection of 9 new commissioners for the next period. 6 out of 9 commissioners are academics, 2 of them are long-serving members of the KPPU, one of whom is a commissioner from the previous period, while the other one was a former staff of KPPU. Shortly after their appointment, the new commissioners held their very first commissioners meeting to elect the new chairman and vice chairman of KPPU, Kurnia Toha and Ukay Karyadi. This new appointment is expected to bring new direction and approach on the enforcement of competition law in Indonesia. One of the most anticipated changes is the improvement to the KPPU case handling procedure. Over the years, there have been considerable criticism to KPPU case handling procedure, which by many legal practitioners is seen as incompatible with the due process of law principles. For example, in relation to the role of the commissioners in investigation and examination stages. Currently, the KPPU case handling procedure is governed under KPPU Regulation Number 10 of 2010, where examination of alleged violation of the Indonesian Competition Law or ICL is carried out in the hearing. Here, KPPU investigators perform the role of prosecutor, who present their findings in the investigation stage before the Commissioner Assembly. In turn, the Commissioner Assembly performs the role of a judge, assessing the arguments and evidence presented by the investigator and the reported party to determine whether a violation of the ICL has actually occurred. In practice, there have been problems regarding the objectivity and impartiality of the Commissioner Assembly in the examination process. For example, there have been instances where the Commissioner's Assembly directed the investigator to ask questions to a witness in a cross-examination session. There have also been some cases where Commissioner Assembly based their decision on evidence that was acquired by the investigator in the investigation stage, despite the fact that such evidence was never cross-examined and verified by the reported party in the examination stage. Such problems occur since the current case handling procedures require the commissioner's vote to determine which case will proceed to the examination stage. Before voting, the commissioners are presented with the preliminary evidence put forward by the investigator. This evidence has not been cross-examined or clarified by the reported party. Therefore, even before the examination stage commences, the Commissioner Assembly already has a presumption that the reported party has violated the ICL. Also, the Commissioner Assembly may have a tendency to declare the reported party as guilty to justify their vote. The new KPPU chairman has acknowledged this problem. In fact, in several media interviews, Kurnia Toha stated that KPPU is currently preparing an amendment to the current KPPU procedure, which will address the problem of the multiple roles of the commissioners in case handling procedure. Under the draft, the commissioners will not be responsible for the supervision of cases, and cases will be handled independently by the investigators without any intervention and directions from the commissioners. This amendment is highly anticipated by many legal practitioners. Many expect this amendment to be implemented this year. This is in line with the statement by the KPPU chairman that KPPU will be refocusing the enforcement of ICL in 2019. In the last 2 years, the number of cases handled by KPPU had been declining compared to 2015 and 2016. This is due to the lengthy selection process for the new commissioners, which lasted for almost a year. However, the implementation of this amendment will depend on the progress of ICL amendment. If the ICL amendment is enacted before KPPU concluded the process in amending their case handling procedure, there is no need for KPPU to proceed with this amendment, as the new ICL will have its own case handling provisions. Next, we will reflect on the merger control in 2018. Since the enactment of merger control regulation in 2010, KPPU has consistently played an active role. We can say that 2018 has become the year of merger control enforcement, considering that out of 16 decisions to date, which relate to failure to notify, 8 of them are issued by KPPU in 2018. We can expect a more stringent enforcement by KPPU, as the current commissioners is very much active in coordinating their monitoring activity with other government institutions. As released by some media, KPPU has discovered that more than 300 transactions were not notified to KPPU at all. So, business, either domestic or foreign, must always check whether the transaction would trigger notification obligation to KPPU. International business should take note that KPPU has the power to review not only domestic but also foreign to foreign transactions, so long as they satisfy all notification criteria. Particularly, we would like to highlight the plan to change the merger control from a mandatory post-closing to pre-closing notification. We will further explore this topic shortly. Now, going back to ICL amendment, there is a high possibility that the House of Representatives will enact this before the general election in April 2019. From December 2018 to now, there has been intense coordination between the government, House of Representatives, and KPPU to finalize the draft. There are, however, several issues that spark debates between related stakeholders. One of them revolves around the proposed change to the merger notification regime in Indonesia, as I mentioned earlier, from post-closing to pre-closing. This has attracted considerable criticism, as many are saying that it will deter investors. This is understandable since the approval from KPPU will be added to the already long list of regulatory requirements. On the other hand, many argue for the pre-closing regime. One of the reasons why is because under the current post-closing regime, KPPU can only impose fines if there is a failure to notify the transactions or comply with KPPU opinion. Even though KPPU has the authority to annul transactions, in practice it is almost impossible to exercise. The failure to notify KPPU pre-closing may cost businesses 25% of their transaction value. Aside from merger control issue, there are debates surrounding case handling procedure. As mentioned earlier, the current case handling procedure is mainly governed under KPPU regulation, since there are no detailed provisions in the ICL. Unlike the current ICL, the draft provides detailed provision on the entire KPPU case handling procedure. However, many believe that this draft merely adapts the current KPPU procedure. For instance, both the draft and current KPPU procedure stipulate the examination shall be conducted in the form of hearing. Many critics suggested that the examination in KPPU should be non-adversarial. This is more appropriate considering that KPPU is not a judicial institution. In addition, the Constitutional Court has confirmed KPPU status as an administrative institution in 2017. We also expect the introduction of a leniency program. With this program, KPPU can review sanctions for undertakings who come forward and cooperate with KPPU during the investigation. Such program aims to provide KPPU with an effective tool in detecting cartel. However, the draft provisions on leniency has raised some concerns, as there is no clear provision on implementation mechanism and the amount of fine reduction. Leniency program is much more attractive for businesses since the draft sets the maximum fine to be 25% of total turnover in the relevant market during period of violation. As mentioned earlier, the House aims to enact the amendment before the general election in April 2019. However, there have been numerous criticism from the Indonesian Chamber of Commerce, Kadin, and the Indonesian Employer Association, APindo, requesting the House to postpone the enactment. This request was made as they consider some provisions in the draft to be incriminating towards undertakings. If the amendment is not enacted before the general election, it is highly possible that the amendment will not be enacted this year. In such case, it is likely that the House will take this legislative agenda to 2020. Before I conclude this episode, I'd like to discuss the recently signed MOU between KPPU and the Competition and Consumer Commission of Singapore, CCCS. This is a significant milestone since it is the first MOU signed between competition authorities in Southeast Asia. The MOU, which was signed on 8 August 2018, is intended to establish a framework for cooperation between the two competition authorities in enforcing the competition law. Under the MOU, KPPU and CCCS agreed to assist each other to the extent that it is consistent with the prevailing laws and regulations in their respective countries. Such cooperation was initiated based on the fact that there is an intense and active business relationship between the two countries. In addition, Singapore is arguably the biggest investor in Indonesia. This may give rise to various cross-border competition cases involving both Singapore and Indonesian markets. A recent example is the share acquisition in Uber by Grab in May 2018, which involved the ride-hailing market both in Indonesia and Singapore. In Indonesia, KPPU, however, considered this transaction as an asset deal, so no notification is required. In a cross-border competition case, it may be necessary to have coordination between competition authorities in the affected jurisdictions. To address this, KPPU and CCCS have agreed on several forms of cooperation, including exchange of public information, notification and coordination on enforcement activities, and human resource development, which includes staff exchange, training courses, seminars, and workshops. Even though the cooperation between KPPU and CCCS is expected to bring positive impact on the enforcement of competition law, it remains to be seen whether it can be implemented effectively. To wrap up our vlog and podcast, 2018 has seen several developments that may greatly affect the enforcement of competition law in Indonesia. It remains to be seen how the new KPPU commissioners will bring new approach to the investigation and examination of alleged ICL violation. It will also be interesting to see how the final draft addresses the issues on leniency, fines, and cash handling procedure. But what is certain is that businesses that are planning to engage in transactions should also prepare themselves for the implementation of the new notification regime. Finally, we have reached the end of the first episode of our competition vlog and podcast series. Thank you for listening, and we will see you on the next episode of AHP Vlog and Podcast.